Deliberation. All right, we're now recording. We're here to deliberate case number 22151 SPH. This is a petition for special hearing in conjunction with Antwerpen versus Baltimore County, basically saying that a special hearing is our version of a declaratory judgment, and that's what we have been charged to do in this matter. Basically, this case comes down to a June 22nd, 2006 order by Zoning Commissioner Wiseman at the time, in case number 2006-051 SPH, dealing with the subject property and the language in the actual opinion, and more specifically, a restriction number 5, saying there's to be no further construction that would obstruct adjacent property owners' water views. So basically, the community association at Rockaway and some adjacent neighbors have brought forth this special hearing in appeal from the ALJ's finding for us to make a factual determination as to whether or not the deck in the back of the subject property is in violation of this previous order. So we've basically are making a interpretation of this order in light of the facts that were brought before us in the de novo hearing. So a lot of photographs of the deck itself. We also were brought up to speed about the somewhat unique history that brought about the zoning order itself and the subsequent owners in between. The house was built in 2006. Current owners evidently purchased in 2021, and there was an owner in between that time frame. So that's where we are. So I think our question basically is dealing with restriction number 5, a little bit also from the language of the opinion itself and from what we saw on the record through photographs and testimony, and whether or not that is in violation of restriction number 5. So opening comments by any of my colleagues on the matter. Anybody want to go first? Fred or Joe, any thoughts?
Well, I want to say one thing first that's a little off topic, actually.
Oh, you go ahead.
I want to apologize publicly to Mr. Zimmerman for my behavior at our hearing. I thought it was uncalled for. Mr. Zimmerman is an exquisite lawyer. He's a very, very well-respected advocate for the public. And I think that my attitude towards him, my treatment towards him in that hearing was shameful, frankly. And I've worried about it ever since, and the world needs to know that that was uncalled for on my part. So I wanted to make sure that that was heard by everyone who was involved in that hearing, because my behavior was inappropriate. So I did want to say that before we get to the substance of anything.
All right. Well, in my experience, Mr. Zimmerman has a short memory and a thick skin, and he probably appreciates your apology. But...
Well, I hope he's got both of those. Yes. I hope he's got both of them. I mean, I can start, I guess. This actually, I found it to be a fairly complicated case. Intellectually, I suppose. I wrote down 1, 2, 3, 4, 5, 6, 7, 8, 9 questions that I had. Only one of which had a clear answer to me. The question that had the clear answer was whether the zoning office interpretation or mode of analysis of an opinion and order, if indeed those are 2 separate things in this case, which I'm not sure they are, whether that deserves any deference. And my answer to that question, which I thought was the easiest question, is no. The position of Mr. Perlow and to some extent Arnold Jablon was that this is how they do it. This is how they interpret it. All they do is look at the what's ordered. They don't look at the body of the matter of the written document. That's not pursuant to any policy that's out there. That's just the way they do it. So it doesn't deserve any sort of deference that we might make to an administrative agency, number one. Number two, they don't really provide any justification for that mode of analysis. And number three, they really just sort of rely on an appeal to authority. That is, they're in charge, and so this is what they do, and this is what they've done, and without any basis in fact, basis in rationality, actually. And then, of course, finally, we have the comment from the Department of Planning, which takes the exact opposite view. So I don't know how we can say one Baltimore County agency prevails in that kind of situation where, you know, the interpretation of a zoning order or of a zoning opinion is interpreted in one way by one agency and another way by another agency, and therefore I don't think any agency gets priority in terms of their view. So that part I thought was easy. It's not clear to me that this is a separate order or whether it's just one document. The order is not set off, or the part that imposes the restrictions is not set off by the word order. It just sort of flows out of the narrative. There's a question, I guess, as to whether condition 5 is ambiguous or not, whether it conflicts with the opinion or not. My own view is that the language of condition 5 is ambiguous. Okay? I don't think it clearly states what the homeowner would have us conclude, which is namely any improvement or any construction is okay so long as it doesn't obstruct the view. I mean, it's not clear to me that is the meaning of the phrase. It might be the meaning of the phrase, but it also might just mean that there can't be any construction or improvement because that would obstruct the view. And one of the reasons that I point that out is that if we accept the property owner's view here, then what it means is it leads to a conclusion which I don't think is rational, which is every time that property owner wants to make an improvement, we have to have a hearing to decide whether it obstructs or impedes, and to what extent it obstructs or impedes. And I just can't believe that was ever the thought process back when Commissioner Weissman did this. I mean, this isn't designed to have, you know, administrative review time and time and time again every time you pick up a shovel or plant a tree or something like that. I mean, it just can't possibly be what was intended. I mean, I think what was intended was finality. This is it. This is over. It's enough. And so I, have other questions, and I can ramble for hours, but my bottom line conclusion is that, number one, we have to take into account the entire decision. Number two, the entire decision has to stand rationally for the proposition that no improvements and no construction of any sort is to be done on the waterfront side. And number three, if in fact this is, if in fact there isn't a flat prohibition, then I would find that this deck, such as it is an obstruction sufficient to trigger number 5, because in great measure because of the elevation of the adjoining properties. In other words, they're lower than this property. So when you elevate this property, that automatically increases the blockage. And everything is raised up. The chairs, the grills, everything is raised up. And that, I think, is sufficient, sufficient under these facts, a sufficient impediment to the water view of the neighbors. So, and I guess ultimately my view is colored. I mean, if this were an Aesop fable, I think the moral of the story would be no good deed goes unpunished. I mean, these people accommodated this house that was built wrongfully, and instead of insisting on drastic remedies, they agreed to the resolution that came here. And I think it's horribly unfair to try and drive a truck through a possible technical drafting issue that would undo what has been a comfortable understanding for the last 16 or 17 years. So I've said my piece.
Red, do you have a piece, sir?
Yeah, just a couple of things. I also struggled with, how do we balance this out and look at the order and et cetera. One thing, Joe, that I noted, you mentioned the Department of Planning. They found that it was a violation of the order, but not an obstruction of the view obstructed. I think in my reading of that, maybe I misinterpreted it, but that's what I found. Second, looking back,
What does that mean?
well, it means that I guess they found that it was a construction or extension under 5, but it didn't obstruct the view. So, but it's still, that's my interpretation of the planning's interpretation of the order of 2006 or 5, right? Okay.
Okay.
My thought is that really looking back and trying to figure out what they were thinking at the time is part of what we're doing here. And they said basically, look, you made a mistake. It seems like an honest mistake. You built the house. It's a big house for this area. It's big, and it was, I think, 4 feet off of what was required. And then they said, okay, that's it. You can't build any more back beyond this. We're giving that up. Then the property owner at the time did. The 81 feet as opposed to 73 feet from the water. I think we heard evidence of that. And I think they basically said, okay, no new construction beyond this. This is it. This is kind of like a trade-off, if you will. I mean, that's how I saw the Wiseman decision from 2005, 2006. I don't see that it obstructs the view of the water. I agree with planning on that. And is this construction? Is it not construction? Is it an improvement? Yeah, it is construction. You got to get a permit to put a deck in. And is it an improvement? Yeah, it improves the property. But does it meet, I think, the intent of really what was meant by the 2005, 2006 order? And I have my doubts about that. Doubts in the sense that I think it can be read together. I think you can read together the order and say, okay, they really didn't want to have a 8-foot extension back here further, build out per se. But I see a deck as not part of that. So my instincts, and I'd love to hear what Andy has to say and further comments from you all. My instincts are basically that uh, that I would allow this deck to stay. I don't think it's inconsistent. I think it can be read consistently with the order. My thought, Andy.
All right. My thought, first of all, because I like to think in a positive fashion, I do have sympathies with the present homeowners because I would like to think that they really didn't know what was about to come up in discussion of this matter. They buy a waterfront place. They think it'd be nice to have a deck. Then it comes to light that there is a lot of history on same. I believe in the order from Zoning Commissioner Wiseman's order, not the order part, in the actual language, he's talking about, he really doesn't want property owners to further benefit from their mistake. Basically, he doesn't want to reap the rewards of making a mistake on one side and getting to have more stuff on the backside. I agree with Joe in that I believe that the order part is sort of ambiguous. And the reason I say that is, I guess if it said totally obstruct, that would be clear and without any type of ambiguity. But this, the word obstruct, adjacent, what does that mean? I'm not quite sure. And that's why I think because of that ambiguity, I think it's fine to consider the rest of the order. And not only the rest of the order, but the testimony that we've heard as to what brought about the order and the circumstances of why it came to pass. And I think that is appropriate. So, and as Mr. Evans spoke about, putting us in the position of being construction police for perpetuity of this property is a pretty onerous situation because say if we were to allow this to go forward or not, we're going to be back. And we're going to be back on, like Joe said, any other thing that goes on in the back of that deck.
Like railings on the deck.
Railings and just any other appendage, if there's to be any type of, umbrellas, roofing, or anything of that sort that might come place. You don't build a deck just to put a few plants out onto. Basically, there's going to be activities of daily living at times that are going to go out onto that deck. And I guess the question for me is, will any of those activities or the things upon the deck lead to a possible obstruction? Now, I don't think there's ever going to be a total obstruction unless people really got out of hand, but I can foresee that there's going to be obstructions that could bring us back here again. And looking into the intent of this situation was basically to make sure that the owner or future owners couldn't benefit from the mistake that was made in the first. And they said that was it. You're not going to have any further development. Now, why in the language they use the obstruction language, creating the problem, I don't know. But I think it's almost counterintuitive to me to believe that it was considered that you could do this deck situation without it falling afoul of this order. So the whole discussion Mr. Evans said about do we look at the order, do we look at the language or whatever, and the different agencies' opinions on that? For me, because there's such contradiction, those opinions don't really help me at all. and I don't use them in considering my decision. I believe as a fact finder for determining a special hearing that we use our own common sense and determine from what we see on the page in the history to make that determination. So, expert testimony telling me how it should be or shouldn't be, I don't think is extremely helpful in this matter, because I think we can figure it out for ourselves. So,
There's also some case law out there that I stumbled over, which talks about what you do when an order appears to be in conflict with the opinion leading up to the order, and what happens if it's ambiguous, what happens if there's a conflict, what happens. And what they do say typically is you send it back to the judicial officer that created the problem where possible. It's obviously not possible here. And if it's not possible to do that, then you're supposed to construe it in a way that's rational and clear and sensible. So,
well, I think that's our charge, is the
Yeah.
construing. And I think that's based on the rationality of what was trying to be achieved. And again, I really have sympathies for the current property owner. I really don't think this was a vast conspiracy to get over on anyone. I think it would be someone's natural desire to have a deck. And especially too, originally, if folks tell you that, oh, it's fine, you think that it's fine, but whether, permits are issued and things of that sort, that doesn't sway our decision one way or the other. That's someone else's problem. And then also too, and this is something I want to make sure that it's clear, is that this board doesn't have any power to order anybody to remove anything either. We basically make a determination. I think it's for other people to determine what goes on afterwards. That's, unless you think otherwise, Joe, I don't think we have. I mean, we make our decision on the special hearing. The other county agencies, they do what they do from there.
that could be. I'm not sure. I think Judge Mayhew ordered it to be removed.
Yeah, I don't know if.
I don't know if that was ultra vires or not.
Yeah, I know that in past matters, I believe we make a determination as to if it's compliance or non-compliance. And then, it's code enforcement at that point in time makes a determination what goes on from there.
I think that might be right.
Yeah, I mean, we're just, it's not, that's not our business as to orders of equity and things of that sort. Anyways, I mean, that's my thought. I mean, I understand the arguments of the homeowners that, really you can see past their deck. I understand that that's true, and I don't want anyone to think that we don't understand the logic of that. But I really have to, I agree with you, Joe. I just don't, I can't get over the fact that the intention that I believe, from what I heard, was to prohibit further extension of this property, either via a deck or something with walls. And just because a deck is flat doesn't mean what's going to go on top of it is going to be flat. And we have the issue with the elevation, which was brought out in testimony quite clearly. So,
and I also think that they can't plant trees. That they can't plant things which are obstructive in terms of the view. I think that constitutes an improvement. And I say that by way of dicta, but
well, I say this, Joe, I'm not even going there.
right.
So
We're in far enough, right?
yeah,
We're in the weeds, so to speak, far enough, right?
Yeah.
Wow.
Yeah. All right. Does anyone else have any further comments?
No, I mean, I understand your position. And I just feel that this was meant, I interpret it a little differently. I feel that it was meant that this construction was a physical wall type of construction, and I don't see it obstructing the view. So I guess I would respectfully probably dissent from this opinion.
All right, well,
Well, I've done it a million times, so,
that's Joe's thing.
yeah,
That's Joe's
I'm
thing.
all over the place.
Yeah.
All right, well, we are a 2-1, and then, guess we'll deal with whatever comes next. We'll issue an opinion with everyone's appeal rights for further review if they do see fit. And we'll go from there. Anything further in housekeeping? Oh, yeah, since it's a special hearing, we don't have to worry about restrictions. We're basically answering a question. So we're just basically, it's not like we're doing a zoning opinion. So, all right, that's what we shall do. And all right, we're signing off.
Okay, thank you
All
very
right.
much. Thank you.
Thank you.
Said Fred, see you in a half hour, huh?
Yes, see you.